Hello, everybody. Good evening. Welcome to April. It is my pleasure to be with you all um, this evening. My name is Carmella George. I'm a VA Accredited Claims Agent, um, and I happily help veterans and their disability claims every day. And I do this monthly to answer questions and give information generally that might help you in your cases and try to, assist veterans any way I can. So this is one of the ways that I can help the most people because I'm limited on the cases that I can personally take. So I am so happy to have you all tonight. Tell me where y'all are from. Where are y'all from this evening? Okay. Hope you are doing well. Hope you're doing well too. We have Chicago in the building. Georgia. We got New Jersey. And Florida. Wow, all over, all over. Okay, guys, so I'm very happy this evening to have with us a special guest. He's someone who I consider, I try to bring y'all the best of the best, and he is someone who I definitely consider to be a star in veterans law. I think he's at the top of his game. I think that he has been very successful in this era, and I've actually learned a lot from him. So I like to welcome Mr. Attorney Matthew Wilcut with us this evening. Hi, Matt.
Hi, Carmella. It's my
How are you
pleasure to
doing
be
this
here.
evening?
I'm
Yes,
doing
sir.
very
Yes,
well.
sir.
I'm glad to see
So
all the people you've got joining us here today. I'm looking forward to it.
we got a good crowd here. We got a good crowd here. Hopefully they're good to us tonight.
I think so.
So, Matt, tell us a little bit about yourself.
So, I'm an attorney who practices exclusively veterans' disability, trying to get their service-connected compensation up to that monthly amount. Of course, I want to maximize their monthly amount, and then, of course, their ratings and effective date going backwards as well. So, always looking for that client who comes to me with a claim where I'm able to try and say, actually, I think it can go back a lot further than that. And of course, everybody wants it to go back, and it's unfortunately more common that I have to say, well, no, unfortunately that old claim closed. But this is the only area I've practiced primarily. I did do. I'm from North Carolina, like yourself. I did for a short time kind of secondary specialize in expunctions of criminal records,
Mm-hmm.
which I did find went with some of my veteran practices um, for individuals who where their criminal record was actually part of their mental health claim. Sometimes that's good evidence as well that there's some markers there for behavioral issues. But anyway, I graduated law school. I had no idea that this was actually an area that I could um, practice in. I just applied for one of the first positions I saw. It was help legal aid, help veterans. I said, sounds good. I've always wanted to help legal aid, and I ended up really falling in love with the work, with the clients, with the practice area, with the community of other advocates. Um, People like yourselves, we're all friendly. We're all advocates because there's so many veterans that need assistance that we're not stepping on each other's toes. We're not stepping on each other's throats and fighting over clients and things like that some other areas of law may have. So that really appealed to me, that this is a community of people who have the skills to help other people in need. And I found that helping disabled veterans just, you know, gives you that good feeling inside, obviously, when you're able to help someone and make a difference and um, help them pull themselves out of maybe a iffy or bad financial situation into an established one. And, you know, the best thing I can do is take someone from being homeless to purchasing their house, or, you know, signing that lease on that apartment. Or
It's a great thing, isn't it?
it is. So it's just real rewarding work. And of course, it's easy to fall in love with. And I've been doing it ever since. So I've been out for almost a decade now. And I've even turned down, you know, other things that I had more experience in law school, you know, things that I had kind of put in feelers with, to say like, okay, well, if this doesn't work out, I'll go back to those things. And then, you know, they reached back out and said, hey, we're ready to talk to you now. And I said, nope, I found it. I'm where I'm supposed to be. So
A lot of purpose in this work, a lot of purpose. So tell us about maybe one of the biggest cases you've won so far. And how long have you been practicing, Matt?
It's been about a decade. I graduated in 2013. And so I've been doing veterans law since January of 2014. I think I became accredited in April of 2014, actually. And, you know, the disclaimer here, of course, for all your viewers is, you know, again, it's not available to everybody to be able to go back to their first application that they made.
Yeah.
It's not as rare as the VA wants you to think, but it is still rare across, you know, the number of people who ask or who want that analyzed. And I'm happy to do it. But clients will come to me and they'll say, you know, I just have this case that's been going on for, let's say, 5 or 6 years.
Mm-hmm.
And I'll say, well, actually, I think I can go back to 1960. I really think I have a good shot to do that. And I recently had the good fortune of doing that for an individual, because the VA just didn't have his records. They were there and free to be available. They just did not have the full set of records available. And so, you know, that was one of those rare instances where you're able to say, you know, he's never then gotten a real review since 1960 when he first applied. Therefore, this is a re-adjudication of the 1960 original application. And I won't lie and say that it was easy at all. It took several appeals and denied claims and going to court and getting it remanded, and then winning with the wrong effective date, and then saying, well, thank you, but that's still not enough and you need to go back. But, you know, when I tell a client, you know, hey, I'm not going to give up on this until you pull me off. You know, I'm a bulldog. I'm ready to go for you. I'm ready to argue this until one of us drops.
Right. Till I can't anymore.
Right. So I've had the good pleasure of having a few of those types of cases. And again, it's very rare. You know, your viewers need to know that is not the norm.
That's an exception to the rule.
But when you're able to do that for someone, obviously, again, it makes a huge difference. It can come with substantial back pay, life-changing amounts of money in the millions of dollars. So that's obviously
right.
Yeah.
So that's great, Matt. Thank you for what you do. Let's hop right in and start taking some questions. We have some lined up already, believe it or not. So let's see. Who is first tonight? Alrighty, here we go. Good evening, Carmella. Good evening. My question is, I'm waiting on a decision to be made regarding my diabetes. I'm currently waiting for a judge to make a decision since July 2020. Is there any chance you can help, or what do I do? You want to take that one, Matt?
Sure. So depending on what lanes veterans choose, and actually, let me even go back further. You know, you could be in the old system that's called the legacy system, or you could be in the new system that's called the AMA system. You know, if you've ever been sent one of those letters that says, well, you can file this kind of appeal or this kind of appeal or this kind of appeal. That sounds more like a new system AMA, as they call it, appeal. If you're in the old system, which was legacy, and they said, if you'd like to continue, you have to file this one specific type of appeal. Everything was very linear. It was A and then B and then C, and it had to be step by step by step. So my answer changes based on, whichever system you're in, because a legacy July 2020 appeal is not actually that old. I've been advising my clients that the timeline is more like 4 or 5 years. That's why they initiated the new system, because of how long the legacy system was taking to get decisions. Now that's with a hearing, which I always ask for. So the answer also changes depending on, did you ask for a hearing, or did you, do you keep submitting evidence? There's a lot of reasons why the timelines will change. So just to compare, I'm just going to, because there's probably 8 or 10 permutations of how this could go. Legacy hearing, about 4 years, AMA hearing, about 2 years. Now that's just to get the hearing. And then of course, after the hearing takes place, you could be waiting about 6 to 9 months after that hearing. So overall, it's as bad as it sounds. I don't mean to be smiling and laughing while I'm saying that. That's a terrible amount of time. But unfortunately, that's what the data shows. If you go to the Board of Veterans Appeals website and look at their annual reports, you can actually take a look at what the data shows for how long certain stages take and things like that. So I would invite your lovely guests to go to the board's website and see if they can pull up the annual report and give it a read over.
Right, Matt's exactly right. It's just taking a long time right now. My legacy cases, even those that have been advanced on the docket, are taking a long time. And so, if you have a significant hardship or if you're of a certain age, you can actually have your BVA appeal move forward, supposedly to the front of the docket. But even those in my cases, and right now I have a couple hundred cases at the BVA waiting for a decision, some in legacy, some in AMA. And I probably churn out 1 or 2 BVA decisions a month, maybe. So, it's just a hurry up and wait type of situation once you arrive at the BVA. So hopefully you get a decision soon.
Yeah, I'm glad you mentioned the hardship or being advanced up for age. Like you said, it's just going to the back of the first line, not the front of the line, because there's already another line of the hardship that's also pretty long.
Right. All righty, here we go. Can lower back pain be claimed secondary to positional vertigo? And if yes, his original claim was secondary to Meniere's was denied. Does he do a new claim, HLR or supplemental? So this might be one that I've never seen, but that doesn't mean it can't be done. It just means that there probably needs to be something the vertigo has done that caused the back pain. I don't see it. I'm not a medical professional by any means, stretch of the imagination. But I just don't plainly see a connection there between vertigo and back pain. Matt, am I missing something? Or
in this situation, I always like to answer it with kind of another general answer back, or a question back, which is to say, can't anything be claimed secondary if there is in fact a theory that makes sense, both from a reality basis, right? It's not based on service in Mars, and a medical basis as well. So, for example, I'm gonna kind of use an analogous, what I think is probably an analogous situation. So I had a client with very bad nightmares, PTSD, and he thrashed around so hard that he broke his wrist. And of course, if you were to just put, I'm claiming broken wrist secondary to mental health, the VA is going to say, what are you talking about? Having PTSD did not break your wrist. So the best advice, generally is that veterans, without cornering yourself, without without saying this is the one and only way that I'm making this claim, you could say, for example, here's why I'm making this claim.
Right.
I'm claiming the back because my vertigo had me fall, and that's a back injury that I would not have had if I hadn't had vertigo. And of course, the secondary question here is, are you service connected for the vertigo? Because of course, if you're not service connected for something like the vertigo or the Meniere's is mentioned here, if there's not an underlying cause, if the underlying cause or primary cause is not service connected, you're going to have to win that before you can win any of the secondary or residual bases that go along with it. And we couldn't even really begin to talk about what option is best there, because that's going to be way too case specific and fact specific and evidence specific. So
Right.
you have to think about which one's best for you. Is all the evidence there? That's an HLR situation. Do you need to add something or respond to something the VA said with some additional evidence or some additional evidence? That's a supplemental.
Right. So, with a supplemental, you have to present new and relevant evidence. If its appeal period has expired on the prior denial, then your best avenue might be pursuing a supplemental claim. I mean, this is a decision that you have to make, but after you evaluate all the options and look at, the time frames, if you missed any deadlines or anything like that. But a new theory of service connection, according to the M21, is in fact should be considered new and relevant evidence. So, just like Attorney Wilcut said, I would make it very clear without boxing yourself in how the vertigo caused the back pain in the claim. Don't just put back pain secondary to vertigo, or they're going to likely the examiner's likely just going to give you a negative opinion. So
yeah. I'm glad you mentioned the deadlines too. I don't know if you've been telling your viewers this on the previous, but the current policy for COVID is very favorable with regional office filings with HLR and supplemental. Now, the same is not true with BVA appeals. So everything I'm about to say does not apply to filing a BVA and NOD, the Form 101A2. But any deadline that might have passed otherwise, but for COVID, March 2020 or later, don't give up on that claim yet as being final. Don't let the VA tell you that claim's been final. You can file it in a very specific way where you say, because of COVID, took me longer than I wanted to file this, but I'm continuing my April of 2020, let's say, denial, and they have to accept that at the regional office for COVID.
Right, and the guidance actually states that any claim where the appeal period ended after COVID started. So if your claim was dated after March 2019, or
No,
March 21st, 2019.
Yeah, it's March of 2020.
Yeah, that's when COVID started. But if your appeal was after that, when your appeal period expires within it, you can still get the extension. I've gotten it multiple times for claims that were like September 2019, but the appeal period ended September 2020. They've granted extensions.
Oh, right. Yeah, the deadline has to fall after March of 2020, not the denial. Yeah.
Right. So, if definitely use the COVID extension to your advantage because it's there, and it's simple to request, and you can even extend the ITF from the guidance I read the other day on the VA intranet. You can even extend the ITF. So use it. While the VA is being lenient.
Yeah, it's one of the most lenient policies they've got.
Right. Here we go. Let me see. Hi, Carmella. Thank you for all you do for veterans. You're welcome. I've had a chronic knee claim denied for years. Injury documented at exit exam but denied. Have diagnosis. So I need a nexus, correct? Um, without knowing all the details of your case and just what you've stated here, it sounds like the element of service connection that you might be missing is the nexus, the connection between the current diagnosis and the injury in service. But what will tell you exactly what you are missing is your rating decision letter. That should have explained the element that you need to satisfy in order to overcome the denial. Um, they're supposed to explain that to you. So I would get that letter. If you don't have a copy, call the regional office or your representative and ask for a copy, and read that letter very closely, and then try to not try to, but find evidence or obtain evidence that would overcome that reason that they gave you that they denied it. All righty. I'm hoping I can get this whole question on the screen. Here we go. Good evening and blessings, Carmella. Thank you for your outstanding service to disabled veterans. Oh, y'all are welcome. It's my pleasure. We love the only issue at this time is when I checked outstanding claims status, the information is saying call the VA regional office. Sounds weird to me. What would you suggest? I don't trust the VA and I have legitimate reasons. Hmm. Well, actually a very good question, and I have personally never seen a status that said call the regional office. That's very very interesting. I prefer just as a practitioner to keep things in writing with the VA, so it leaves a paper trail, and there is a record, an accurate record of what you were trying to accomplish with the VA. But if they are asking you to call them, um, you may just want to do that and either send a memorandum for the record after the call or document what happened on the call, upload it to your file or something like that. But what I would do, as soon as possible is make contact, whether it's through the Ask VA system, the new system they have where you can send a message electronically through to the VA. That might be one way to contact them, or you could just call. Or did they leave a number specifically for the regional office, or do they want to call the 800 number? I mean, there's some that's interesting, and I'd like to know more about what's going on there. But the fact that they're asking you to call them on VA.gov when they could just call you is very very interesting to me. Anything you have there, Matt?
Yeah. So on the subject of getting some assistance generally, one of the things I love is that I'm able to help veterans. Obviously, you and I both take advantage of VA electronic systems, so we have access to our clients' case information. But one of the things that's really sad and unfortunate, and I do not wish that this was the case, I have better access about the status of my clients' cases than they would be able to get themselves, or at least certainly very easily. And so getting assistance of any kind, a VSO, an agent, an attorney, can, if you get the right one with who says, yes, I have the electronic access inside the VA, that's real-time access. I can go on the client's file and see what the holdup is or see what the actual status reads. I saw one of the questions that was coming, scrolling by, was talking about a secondary signature needed, right? That's a very specific status that the case is in. I don't trust e-benefits. Every single time a client's asked me, what does this mean on e-benefits? I've said, I don't know, because that doesn't match the real information I'm seeing in your actual case. I actually refuse to answer e-benefits questions for that reason. I just say, I've just got to tell you, unfortunately, that I think that that's not an accurate system that VA has given. I think they've given veterans a lip service in technology form that just tells them something, hoping that'll satisfy them. So I think the better advice to finding out what a specific status is in a specific moment in time, provided that you definitely need that information or strongly want it, is to get somebody who get an advocate who has access to that kind of information. It's sad that I have better information than a veteran does. That doesn't make sense to me, but it is the case.
Right. And I think in the case of Miss Jones here, her husband is already at 100% and receiving SMC. I'm I'm pretty familiar with her case from questions in past months. So I think that whatever they're asking you to call about, it's a very interesting situation. You just might you don't need a representative for. You might just use a VSO just to get through to the VA for. You don't need them for anything else. So what Matt said is very, very true. Okay, so our next question here: denied service connection for flat feet. Should I go secondary to ankles 10%? Um, it's an interesting question. There's a couple things you could do. You could look at the reason for denial, that they gave him the rating decision letter. Why did they say that your flat feet were denied? If you can get evidence that could overcome that reason, or you feel that reason is invalid and it should get further review or something like that, you could request an HLR. You could go with a supplemental with new and relevant evidence, or you could take it to the board on just the flat feet. So evaluate why direct service connection for flat feet was actually denied. You need to know and understand, that part of it before you take the next action. But the good news is that the secondary, route is an option for you. Um, Generally, I'm not a medical professional, but I see feet secondary to ankles. I've seen it multiple times. I'm not saying that's true in your case because it's individual to, in fact, specific, and a medical condition is very specific to the individual. So it's not that an examiner will say yes automatically. It's not that the VA will say automatically, or that it's any easier than direct service connection, but it's a possibility. So, but find out the facts surrounding the denial for direct service connection with the flat feet and understand the denial reason. And then, you might want to evaluate whether going secondary is the best route. A representative might be able to help you do that. I miss anything there, Matt?
I would also, make sure to follow where the medical evidence goes, because let's assume that the feet are, in some situations, a recent occurrence. I mean, they're not long-standing issues. They weren't always there. That's why it's secondary, and that it's not directly incurred from service. Maybe they only popped up in the last couple of years, or maybe they've been there for a while. But does the medical evidence around the time that the feet showed up show that the ankles flared up? Was there a fall related to the ankles? Was there some boot that you were in on the ankle? The possibilities are endless, because it really is just what is medically possible. This sounds plausible. This sounds we wouldn't know how likely it is unless we were looking at the specific evidence in the case, but it at least passes the smell test. Like Carmella said, it's a very common type of claim to see, and just make sure that your evidence backs up your theory.
That's a great way to put it. What does your medical evidence show? What does your record show? Follow that. That's great. Okay, here we go. Should I file a Q to change my separation code from personality disorder to major depression? Additionally, if changed, will I be considered medically retired? That's a good question. Matt, you want to take that one?
Well, they're using both military and VA terms there.
Mm-hmm.
So the first point would be some of what you've asked about is a military issue, changing separation codes, medical retirement. That's something that you actually have to take up with the military boards of review, which is a whole nother area. That's not something that Carmella or I do. We interface with the VA on behalf of veterans. So there's military benefits, there's VA benefits. Some people can get both. Some people can only get one or the other. That's a whole can of worms in and of itself. But there is such a thing in the VA world of CUE, which is that clear and unmistakable error that I was talking about in the very beginning, about going back from a previous claim that had been adjudicated, maybe even in the far past. So that's a thing. And then, of course, it is common to see, still in this day and age, the claims of individuals who were wrongly diagnosed with something that maybe even at the time was the prevailing medical consensus. But we now know more information about mental health. We now know better than to have labeled as many individuals that got assigned a personality disorder versus depression or PTSD. There's a reason we don't call it shell shock anymore. That word has kind of fallen out of favor. We use the clinical terms that are in the medical community to better and more appropriately reflect what the claims are. So I would advise anyone just in general who's got a personality disorder diagnosis, and that may be a big barrier to getting the VA benefits for the claim. I don't know about on a CUE basis, but certainly your hump that you've got to get over is to say, I really strongly question whether that personality disorder diagnosis was right. And can't a medical professional take a look at my case and say, you know what, that actually probably was more likely what we would call today PTSD or major depression or unspecified anxiety disorder. I mean, whatever that medical professional's opinion may be, I wouldn't begin to be able to point to one diagnosis or the other. But all I know is if somebody comes to me with a personality disorder diagnosis, I'm going to immediately say, we challenge that. We say that that's not right, and it is something that today would not be called a personality disorder, and go from there. And just again, you just got to kind of let the medical professionals do their work from there and see if they agree or don't disagree. And if they disagree, do they disagree for the right reasons, or have they got it all wrong? But that's where I would start.
Right. There's some information floating around about the number of people that were diagnosed with personality disorder, which I think what Matt was referring to. I don't know whether it's a study or just an article, and during a certain time period in the military. And if, your case was during that time period, you might want to get it relooked at. I don't know whether you didn't say what your discharge was, whether you need to pursue a discharge upgrade, or you're being barred from VA benefits altogether right now. But if it is barring you from VA benefits, you definitely want to pursue that, things on the military side to get it changed. If it's not a bar to benefits, you've been diagnosed with depression and it's service connected. I don't know that you would need to file a Q. So a Q is a very clear and unmistakable error, is a very high legal standard, and you don't want to file one when you could take another route to get where you need to go, if that makes sense. So it would be my suggestion that you find some sort of representation and look into what needs to happen in your situation on the military side and on the VA side.
Can I add something real quick to that
Yes.
as well? I always advise individuals where you mentioned the barrier to service. Sometimes the VA will say this is a regulatory or statutory barrier based on the discharge type. You can win a claim on the VA side and resolve it. You may need to prove what's called insanity, and insanity is a very specific term of art. I want to be clear. It's not what, hearing that word now, if some of you have never heard of insanity, it's not what you think it is. It's a very specific legal term of art. It's defined. It's something, I assure you, it's something more common than what you're thinking it is. And you may or may not need to pursue the military side of things in order to get benefits. I've won clients' cases, and again, not on a CUE basis, but for adding records that go all the way back. But I've won it where we get PTSD recognized all the way back in Vietnam that was mislabeled as a personality disorder, and then they didn't need to do a discharge upgrade. Now, of course, I would always tell a veteran who doesn't want to have that paper say what it says, to please, of course, even if you got the VA benefits you were looking, that doesn't mean you're happy with a discharge saying something that reads, something other than the truth. But you don't. I just wanted to make the point. You don't have to pursue something through the military, and the VA is pretty bad about telling you, we're not going to look at you. Listen, we've looked at, you've applied 7 times now, and we've told you you've got to go through the military. And I would just caution against getting some assistance before you just take the VA's advice at face value. That may or may not be true.
Right. And I've won an insanity case before, so it is possible. And look into the VA's definition of insanity and see if it. I don't know all the details of your case from your question, but definitely listen to what Attorney Wilcut is saying, because it's very good information. All righty. Can you claim anxiety secondary to tinnitus? Not a medical professional, but I see it, and I see it pretty often. So it is a claim that is possible. It just depends on whether it's, the reality in your situation or your medical records either demonstrate that, or, a CMP examiner will confirm that. So can you, but the question was, can you? Yes, you can definitely do it. I'm already rated, but some of my service-connected medical conditions were not listed on my e-benefits. Does it matter? That is interesting. Matt,
Like I said earlier, I don't put any stock in what e-benefits says at all. If you could send me a printout of e-benefits, and I'll say that means nothing to me. That's just, for whatever reason, the VA has chosen to put something up on e-benefits. That's not the system that they use to adjudicate benefits. So I don't know why e-benefits reads what it reads, but you can't rely on it in any sense.
yeah, I see mistakes in the system often, and that their system for keeping veterans updated. It's what you really want to do is get your rating code sheet or and see what's listed there as your service connected conditions, and that will tell you what certainly what you are service connected for and what you've been denied for, and go from there. I said, thank you for taking the time to doing this. You are very welcome. Very, very welcome. All righty. Why is sleep apnea so hard to service connect? That's an interesting question.
That's a very timely question.
Mm-hmm. You want to take it, Matt?
Well, until about, I don't know, 5 or 6 months ago, I didn't think it was as hard as it's since become. I would point your viewers to the Federal Register, or I couldn't give you the URL or the link, but Google Federal Register sleep apnea, and you'll see that the VA's proposed to change the way that it's rated. And in a sense, although of course no one at the VA is going to openly admit it, it seems to me that based on just how hard it's been to service connect it recently, I see a lot of the CMP examiners using very copy pasted denials, and it's like, well, how could you say the exact same thing in 5 cases? How does that mean that you did a case by case analysis for this veteran? But I think that even though they've proposed to change the way they rated it, I'm of the opinion, and this is just my opinion, that they have in practice somehow, through the grapevine and formally, whatever, it's worked its way down, made it harder to be successful in those claims. Again, that's just my anecdotal data over the last 6 months or so, but it seems fairly convenient and kind of fishy that they would propose to change it, because that lets you know where their intent is, and at the same time, it gets really hard to win those claims. You can still win them, and this person who asked the question didn't raise a specific theory or what it's service connected to. I commonly get it granted secondary to mental health, commonly get it granted secondary to diabetes. There's an entire line of cases. The Larson case, Larson, talks about what happens if you had an injury and that injury took you off of your feet. I have clients who wear a boot or a cast for 4 months, and they gain substantial weight, are unable to do physical activity, and their doctors are telling them, listen, if you don't get your weight under control, you're at risk of developing sleep apnea. They don't get it under control, and then they develop sleep apnea. Mm-hmm. I don't understand why I'm having as much difficulty winning those claims when that's in the record and that's how it's documented, that that person had an injury, they gained weight, their doctor's warning them if they gain weight, they'll get sleep apnea. I mean, it just seems like it's a very nice chronology that the medical evidence lays out, and yet the CMP examiners will deny it and say, "Oh no, he just couldn't control his caloric intake. He just ate too much. He, nothing about his service-connected conditions have anything to do with why he's developed sleep apnea." So, I think this person asking the question has hit on something that's today is a very controversial issue in the advocate community. We're all talking about, why is this so hard now? What changed? And it's clear the VA wants to not be granting this as much. So they're just not. They're just putting up more barriers and making up reasons to deny, as far as I'm concerned.
I would agree with that assessment. Okay. Okay. Have you had a veteran's claim who has to wait on getting records from a U.S. domiciliary center? That sounds like a radiation exposure claim. Am I right, Matt?
I am not familiar with trying to get that type of record. Now, during COVID, depending on the facility, yeah, I mean, currently there's some issues with trying to get records and waiting, National Archives and things like that. So beyond kind of just the COVID-ness of the times, I'm not familiar with that specific type of request. What's funny is I've even got, just behind me, there was a radioactive veterans special.
Yeah, it's a radiation claim.
Right. I have not had those types of claims, if you can believe it. In my 10 years of doing this, I've really never actually had somebody come to me with that type of claim.
Really, I am dealing with a DIC case right now that had to wait a significant amount of time for them to go to that center. I'm not sure how to pronounce that word. Forgive me, but they had to go find out if he was exposed and how much he was exposed to. So it turns out they couldn't find any record of him being exposed, which is, quite a situation for somebody who ended up with a bad brain situation, and passed away from it. And his, private physician is saying the brain condition definitely shows he was exposed to radiation in service. But that's neither here nor there. We are trying to figure it out now. But yes, they did have to wait on the VA to go find, ask for those records.
Yeah, and I guess the thing I would add, just in a general sense, is, are you waiting on the VA to go and get those records? Did the VA say that they were going to go and get those records and they just haven't done it? Do you know whether they in fact have sent the correct record? Did they word it right? I mean, a lot of this depends on, did you make your own request for the records, which I would always suggest. Sometimes the facilities will say, do not send a duplicate record. Well, again, just to running theme here, I don't trust that the VA sent the right records request. So I'm going to send my own records request to anywhere where I think, has records that I need. So hopefully that's helpful.
Okay, that was really helpful. Really good point there. Okay. Will a supplemental claim for sleep apnea and headaches for back pay that I've kept alive since 2015? Good job. Put my 100% PNT for depression and anxiety that was awarded in 2020 in jeopardy. It is my opinion, based on the facts that you've given here. I've not reviewed your file and don't know all the circumstances of your case, but generally, I would say that it should not, if you don't, specifically open up the depression and anxiety, but they could, it's a possibility, I don't know the how big of a possibility it is, or how likely it is to happen, that they could find some type of error with your mental health or something like that upon review of the file. So every time you open up a file, you there's some slight possibility that they could. It is not procedure that they do or they should, unless it's a clear error that they find upon their review. So my take might be, based on what you said here, that it probably shouldn't put it in jeopardy, but be aware of the possibility. Anything to add there, Matt?
Well, my answer, I had an answer developed in my head until I noticed that it's about permanent and total.
Mm-hmm.
So the pushback I would add there is it should be even less of a chance of it, since it was just awarded, as being
Mm-hmm.
permanent and total, because um, when someone is given a permanent and total rating, that's the VA making a what in now in 2020 is most likely a binding decision that it is permanent and total. So if they wanted to try and pull that back, claw that back, that permanent and total, they would have to prove CUE on their end. They would have to say we never should have awarded PNT, not that just it got better or there's been some improvement. So the permanent and total, being rated at 100% is great. Being rated at 100% permanent and total is even better. It happening in 2020 most likely was an AMA decision, which comes with binding favorable findings. And so there's some protections that are probably at play. Now, again, all of that's in the caveat that no advocate can ever guarantee you anything. And certainly when it comes to the VA, I could never take anything that off the table from the VA. But um, I did see it recently where my one of my clients claimed sleep apnea, and what happened is the medical opinion came out that the veteran's mental health is so severe that they were going to grant sleep apnea. The thing was is that he wasn't rated that highly for mental health. So what actually happened is they then did order him a mental health exam, and he got an increase. He had only filed for sleep apnea, but he ended up getting an increase for mental health out of it. So it works both ways. It basically, again, as Carmella said, the main thing is that anytime you're interfacing with the VA, putting in claims, even old appeals and things like that, you're giving them the chance to look at something. And I can't explain why the VA does some of the weirdest, stupidest, kind of vindictive looking things that I've seen them do. But just know that because I've seen it, I've got to tell you that sometimes I've seen it. It shouldn't happen, but that's why it's important to act quickly in those circumstances when it looks like they're trying to do something that is adverse. Certainly, if you've ever been given a letter that looks like VA is going to take some adverse action, if you don't have assistance at that point, then I would highly advise you to run, not walk, to a VSO or an advocate or an attorney.
Right. And, I should add that a safer route than a supplemental claim might be to take it to the board, if, or use the evidence laying at the board, to lower the risk that they might find something else. But the risk is not very high anyway, in my opinion. But you have to evaluate the facts of your case. I don't have all of them in front of me. I haven't reviewed your file. So
It sounds like he might be saying that he would opt into the AMA from a legacy appeal as well if he's kept it open since 2015. My personal view is I keep everything legacy. They're clearing the legacy docket, and I'm saying this kind of like matter of factly, like they're literally clearing the docket of here's our inventory of legacy claims. If you're on that list of claims that's legacy, they want to get rid of you. And I tell my clients, well, I know of only one way that they're going to get rid of us is when they grant the claim. Versus if you opt into the AMA, you're now just one of, some incalculable number that's in the new system. And there's no pressure on the VA to clear your case. You're not an old case anymore. You're viewed as a new case. And for that reason alone, I did not opt in any of my clients, save for maybe I could count on one hand. I did not opt in any of my clients into RAMP, and I strongly urge none of my clients to opt in to the AMA from Legacy. Again, I've done it a handful of times, but it has to really truly make sense and have some tangible, actual benefit that I can identify, that I can wrap my hands around at that given moment and say,
right.
If I make this change, I'm going to get this benefit by doing it.
Right. And I agree 120% with 200% with the assessment that Matt just gave. It is my opinion that AMA so far, it's been in effect since February 19, 2019. And it needs some retooling to be more effective. Not that it kind of improved things. It's supposed to be a lot faster than the old method of appealing in the legacy system, but it needs some work. And so, I am a fan of keeping things in the legacy system too. Generally, unless there's a good reason not to. And if you're in the legacy system, you really want to look at before you hop in the AMA the advantages, the pros and cons before you are to take that action. Because like you said, you're in the legacy system at the BVA, and they're wanting to get rid of those and things like that. So there's a whole host of reasons I could go on about that. But I was listening to a panel at the CABC today about the AMA, and it's very, very interesting what advocates are doing. How many are choosing to stay in the legacy system. I think it says a lot about the new system, but that's a topic for a different day. I filed a claim for PTSD in 2009 and was denied. Filed an intent to file in May 2020. Filed another PTSD claim 2022 and received a rating in February. Wow. Will I get back pay from 2009 or 2020? Thank you. So this is kind of what Matt covered this a little bit earlier when he was talking about effective dates in his opening. Basically, the general rule on effective dates is it is from the date of claim. There are a couple of exceptions to that. They're pretty technical. And then there are amazing attorneys like Matt that can make things happen from nothing. If you keep pursuing it, to a certain degree or a certain level, you have better chances of it going back. It's all fact dependent on the specific facts of your case and circumstances. But it sounds like from what you said here that you missed the appeal period in 2009. Oh, sorry about that. You missed the appeal deadline in 2009 and the claim became final. And that presents immediately and presently presents a barrier, but it might be able to be overcome if there's certain facts in your file. So what I would highly suggest is that you get a professional to review it. And if you can't get your file and determine that yourself, that you get somebody to look at it and just make sure that there's no way for it to go back to 2009. There just might be a chance. Well, it's not very likely. There might be a chance. Matt?
There's an assumption here in the question, which I noticed, which is noticing the 2 years or year and a half, maybe between 2020, May of 2020 and the filing in 2022. It's an open question, I think, still. I hope this person did get at least the May 2020, but it's an open question. That COVID policy that I mentioned at the very beginning, that's very favorable. Do you have to affirmatively invoke that at the time that you file your claim that you're wanting to utilize? So in this example, which is a very common situation, an intent to file May of 2020, ordinarily that's going to expire May of 2021, and we're given the hypothetical in this situation of a claim not filed till 2022. I would be more shocked if the VA didn't only grant this back to 2022, and you'd have to say, well, wait a minute, what about my May 2020 and the COVID policy? And again, I think it's an open question whether the policy is applicable in the general sense, or whether someone has to use the magic words. Like they sometimes, the law does sometimes require that. Like when good cause is the basis for a late filing, the law is allowed to say that good cause has to be openly declared. I am recognizing I am filing this late. I am using the magic words that I have good cause why I filed it late. Therefore, please don't consider it late and actually consider it timely, and then the VA will adjudicate that. So I'd be a little, the person may even be getting ahead of themselves here and thinking that they're going to get 2020. I hope they did at least get that, but they may even be getting ahead of themselves in that situation. And I can see that they scrolled up and actually said they wrote a wrong date, but my point still stands that the COVID policy itself may in fact need to be invoked. So keep that in mind. That I don't want you to say Matt Wilcut said that COVID, all deadlines are off and it's a free for all, right?
Right. It is a pretty liberal policy. I mean, look into it, decide what's best for your case. But I posted a few months back, maybe 6 months or so ago, that I am seeing significant errors with effective dates at the regional office level. It's just over and over and over again. They're even using the date of the supplemental claim and not going back to, a continuously pursued date, or using the date of exam or something like that. So you need to make sure, or be sure, double check when you get your rating decision and your, representative checks, that your effective date is correct of your claim. Just generally talking about effective dates. How many intent to file can I have with the VA? Not ready to submit all the claims at once. So the policy actually states that you could have one intent to file at a time. That's what the M21 states. That they consider any other intent to files filed after that to be a duplicate, and that's until you satisfy the intent to file on file. If you have a claim pending, you can file another intent to file as soon as you file that claim, and then you have a new one open. I've heard some suggest that you should always keep an intent to file open, and I think that in most cases is a good advice, especially in these days where presumptive burn pit and toxic exposures are being discussed. They're becoming, they might be service connecting presumptively more things. If you're Gulf War, or you definitely want to have something on file in case they, make those things presumptive and they don't go back automatically. And in case they make those things presumptive and the law or the policy doesn't say that they will go back. So at this point in time, it's good to have an intent to file on file. I know that wasn't your question, but I wanted to say that anyway. I was thinking about saying that tonight. There, you can only have one at a time according to my knowledge and my reading, but I would always keep one on file. Did I miss anything there, Matt?
Just that it recently became both more favorable and more confusing and complex at the same time. So when the AMA came out, they confusingly decided that they weren't going to honor intent to files where a supplemental was the next thing that got filed. Mm-hmm. It could only be a 526 EZ would be the only form that one could file where an intent to file could preserve that date. And advocates said, that doesn't make sense. And recently that went to court, and we won that argument. So the court invalidated the VA's regulation. Yes, you can now use a supplemental, but now the problem with that is this person indicated submitting different claims at once. Are some 526s, are some supplemental? It's going to get used up by whatever the first thing you submit. So if you did a 526 1 week and a supplemental the next, it's only going to apply to that first one, not the second one. It's used up the moment it attaches to some other application.
Unless the different claims are filed the same day, is what the policy says. If you file it the same day before midnight, and it's a 521-6EZ or a supplemental or higher level review, well, not high, it doesn't apply to higher level review, but supplemental or 520 original claim, then the the tentative file should attach to both. Only if it's filed
So
the
do
same
it at
day.
the same day. If you're going to do a couple of different filings, do them all on the same day.
Right.
Yeah.
That would be the best direction. Can I submit evidence from my claims file along with BVA direct review form since it's not new evidence, just evidence I want looked at? You can always present argument and then have some exhibits attached to it and things like that in the direct review lane. But they won't look at anything new. So as long as it's not new, feel free to submit it or highlight it for the judge, and you should be fine. But just make sure you're not submitting new evidence. But you can submit an argument. You can write out the facts of your case and how the law should be applied to it. That would be beneficial to you, and that's usually what a professional can do for you. What are the requirements for R1? I'm assuming you're talking about SMC, and I wouldn't know that off the top of my head, Matt.
I wouldn't either. I'd have to Google it. So there's an alphabet soup of special monthly compensation. So for your viewers, think of Googling SMC parentheses R, SMC parentheses K, SMC parentheses S. There's pretty much all the way up to I don't know how high it goes. Obviously, it goes up to at least R, but you should be able to find resources online that discuss that very specific form, because there are so many different types of special monthly compensation. And just like Carmella, off the top of my head, that I don't even know which one that is. So looks like aid in attendance is one of it.
Right, then your service-connected disabilities need to, affect your activities of daily living.
Well, there's R-1, there's R-2. So there's a couple of different things
probably
there.
Get with me offline. It's free. I'll try to give you more information on that.
Yeah, aid in attendance though is probably one of the least understood types of claims that actually I think is like I said with CUE, it's rare, but it's not as rare as the VA wants you to think. They want you to think it's something so rare and you're not deserving of that severity, and you're like, but it sounds like I qualify. It sounds like my client qualifies. Do they need daily aid and attendance from another person? Yes. Is it for service-connected reasons? Yes. Then why would they not be granted daily aid and attendance? Now, of course, that's the common sense argument. That's not the legal argument. But it may be as simple as that. But then again, you've got to show all the evidence with how often that aid is provided. Is it really regular? Is it actual aid with types of daily activities, or is it something else? So like getting aid, getting someone to help you with a hobby of yours. I'm just making up an example. That may or may not be aid and attendance, because that's not aiding you in your daily activity of living. But I find most of the time that it's a spouse, it's a wife, it's a husband, it's a child, it's a parent. If they're providing what looks like what somebody would provide home health care for, then you've got at least a good colorable argument, and you should look into whether you should be getting the aid and attendance rate, even if you're already at the 100% rating, because the aid and attendance is higher than that. It's special monthly compensation because it's above the 100% rating. Now, sometimes it's not always, we're not talking leaps and bounds above. It could just be a couple $100 a month, but over time that obviously adds up. I mean, everyone should get what they're entitled to get. It's not a question of wanting money over not wanting money. Everybody wants money, but the law's there to provide benefits for people that should meet that.
Right. And the Secretary of Veterans Affairs stated just yesterday in one of his speeches that you're not going to take benefits away from anybody else by claiming your benefits. They have enough to go around. He said, file your claim. And I would echo that sentiment. File your claim. I hear a lot of veterans say, but people deserve it more than me, blah, 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 blah. If you had this, injury, event, illness in service, or something that is directly related to service, or secondary to your service-connected condition, or, medical treatment at the VA caused your condition, or it's aggravated by service-connected condition, file your claim and don't wait any longer. All righty, so we're going to go for just a little while here, probably about 10 more minutes, take a couple more questions. But I know we're not getting through a lot of questions tonight, but I feel like we're answering them pretty thoroughly. So
I'm wondering, tell me if I'm going too long.
no, you're fine. You're fine. When we break things down real well. So I think that helps a lot of people. Okay, here we go. I have a case where CID, I'm not sure what that is.
Criminal investigation.
Took me off base at Fort Carson, Colorado to make a drug bust, and I was rear-ended, totaled the car 3 days in the hospital in 1994. My appeal is waiting to see a judge. It's been 2.5 years. What should I do? I claim PTSD. I'm getting disability for my back, neck, and knee. 30%. You're only getting 30% for your back, neck, and knee. My first piece of, well, based on the facts that you've said, generally what I would tell somebody that has a situation that sounds like yours might be that you want to evaluate the 30% you're getting for your back, neck, and knee. That sounds a little low to me. Just given those disabilities, and maybe it's just one knee, 10% you have for each of those three things. But you could probably push that a little higher if it's worsened at all. And then concerning your BVA appeal, been with a judge 2.5 years. It might be in a legacy system. You claim PTSD from the accident, and you don't say the reason for denial or anything like that.
Yeah, I'm not sure there's enough to go off of here that
I
haven't already said in some other answer.
Right, any road direction. But if you're not represented, you might want to seek representation so they can look at your case, or you want to make sure that you're prepared if you have a hearing to go in front of the judge, that you have your arguments laid out and you know what it takes to meet the criteria for service connection for your case. Be prepared to articulate your case for yourself, give your testimony, bring any witnesses, and lay your case out to your benefit. Or, and if you didn't choose the hearing lane, you might want to give some written arguments to support your case. If you're still in the legacy system, you can add new evidence. And I would, might say that you would want to do that. Take advantage of every opportunity you have to prove your case. So don't just rely on what's already in the record if you're in the legacy system. So
I thought of something else while you were speaking, which is they said they were waiting to see a judge. They just came out with a statement, and I think they put these in the letters now. If you change your request from either a travel board hearing or an in-person hearing, which is going to take forever, to a virtual hearing. Now we do virtual hearings, which is not too unlike, imagine if I was the judge and Carmella was the veteran, or Carmella's the judge and I'm the veteran. These are virtual hearings now. It doesn't require anything more than a laptop or a desktop with internet connectivity. And you can be talking with the judge. And I do agree that would be the fastest way to see a judge versus the other options, right? Versus waiting for the judge to come to your city and go to the regional office, or for you to go in person anywhere and do anything like that. So that could be one way to speed up your wait, is to request a virtual hearing if that's something that you have the capability to do.
Okay, I think I skipped the question here. I'm going to go back to it. I'm sorry about that. I try to go in order. It's a long one. There we go. Okay, we're going to try something different today. My question is something very unique. I have service-connected issues. One, I served in Desert Storm, which is my ship at the time was infested with asbestos. Since they are already tracked asthma, and I was told from the VA to file for bronchitis, seeing this, someone found that I was exposed to asbestos was true. In 2007, I was diagnosed with C1, C2, C3 cervical, uh, neck, which was notated at the. I can't see the rest of that question. I'm so sorry. If
Yeah, I don't know what they're asking, unfortunately.
yeah, I'm so sorry about that. But you can get with me offline. I'll try to answer that. I'll give you, provide some general advice. Um, Here's a good one. Can filing for increase jeopardize an existing rating? So the answer is that if you're filing for increase and you didn't necessarily provide evidence enough evidence that's sufficient to rate your case, then you will have to go through another exam most likely. In most cases, they will order an exam. If that exam finds that you are better and have improved, then you have the possibility of reduction, or there's due process. You can fight that type of thing that will take place. But um, if your condition has worsened, um, I don't think I would not think that you would be in such a position that would jeopardize your rating. I wouldn't use the word jeopardize. There's always the possibility when you file any claim that the VA might look at it and say, hey, well, either they could deny it or they could say, hey, you might have improved. But if you haven't actually improved, it's gotten worse or a lot worse. Um, you know, it's not a real possibility in my mind. So
I find the more recent you got some rating, and basically as time goes on, the risk that something is jeopardized or is going to have some adverse gets better. So if you've had a rating for 5 years, certain protections kick in. If you've had a rating for 10 years, even more protections kick in. If you had it for 15, so and so. If you just want an increase for this is a common one. If you just want an increase to 70% for mental health and you're trying to get 100%, you're absolutely at least opening the door that the VA could say, well, actually, now the more recent records say it should be 50. I know we just gave it to you 70, but that was based on that evidence at the time. Now we want to drop it down to 50. Because they just gave it to you, they only have to then look at the evidence from after they gave it to you to the day you filed your increase and until they adjudicate it. And if that evidence doesn't make it sound like it's as severe anymore, that's what they're going to act on. So, the reason older claims provide you more protection is there's a wider history of the evidence showing that it's remained severe. There's also this concept of what's called a stabilized rating, where it's a little bit like what I was talking about earlier with the permanent and total. It's stabilized to the point that the evidence really shows it's not going to get any better. It may get worse, but it's certainly not going to get better. And certainly if you can get a doctor to say that, that would be very helpful. But I think the most important factor to this question is time since receiving the last increase for that condition, because again, it's facts and circumstances, but in general, my general advice is the longer it's been, the safer it is. It's never completely safe. It's never even really completely safe after something like 20 years, because they can say that you committed fraud to get it. That's the only reason they can do it. But for most people, 20 years is like the best time to do anything where you know that you've got no danger to your case. That's where it becomes that's where it reaches its highest level of protection.
that's correct, very correct. Here's an interesting question: can married veterans both receive aid and attendance benefits simultaneously? Um, so, to my knowledge, yes. Um, Veterans benefits are specific to the veteran. So if we were to qualify for benefits and meet the standard for aid and attendance, then yes, they could receive it. It's almost like when two veterans are married and they both have kids. Yes, you can both claim. You can both have them as dependents on your award. So
I wonder if the hypothetical situation in this situation is two veteran spouses taking care of each other, and therefore
That would be interesting.
trying to get aid and attendance, and I don't mean to put a negative on trying. They could do that in my mind because the situation could be that this person has a very specific set of needs that only their spouse can provide, but they can't. But the other spouse has another set that they can't provide for themselves, but their spouse can. And that doesn't mean, well, each of them could just be doing it themselves if they're both taking care of each other. Again, that's very fact specific, but I could see it. And then, of course, the other situation could be that both veterans need assistance from outside parties. That would be the for the VA, for the VA, that would be the easier case if both persons needed help and were not providing that kind of assistance. But I could see it either way. You just have to get, I don't want to say creative. You have to be clear why both would need it and why both getting it doesn't mean that one of them should get it. You just have to, I would just be very open and upfront and honest about the type of assistance that needed and why, you're not trying to get something that you're not entitled to.
Right. Good point there. Okay. Just a couple more, guys. Diagnosed with spina bifida, 1987 in Panama, denied claim back in 1992. You were on active duty when it was diagnosed? Her next comment says don't have, or his next comment says don't have spinal MRI done.
I wonder if they're saying that the VA is saying it's a congenital spina bifida, but it's actually some injury that was incurred in service.
And it sounds like there was a misdiagnosis too.
Yeah, I've seen that happen. I've also seen the VA give benefits for something like spina bifida and then come back and say, oh, actually it was something else and we've changed our mind and we want to take it all back. And I've had to represent the veteran to say, like, you don't have the evidence to that. But it's a little unclear what's going on in this situation.
Right.
Maybe wrong diagnosis, and maybe pretty reliant on current evidence and not the evidence in the past as much.
You might want to get a professional look into that, and
I think that's going to be in the hands of a medical professional, not so much a legal argument.
Here we go. I'm 100% not PNT. I have a CMP coming up for both hips. This is the only condition not static. In your experience, what kind of evidence do I need to convince them to make it static? Award PNT. So I deal with a lot of cases that are 100% schedular and not permanent and total. I've had, I'm not going to talk about, my success rate, but I've done it, converted it many times at this point. And, what the M21 says about it, and that's not law nor regulation, it's just procedural guidance. It says that it's in the discretion of the person making the decision. Doesn't say what kind of evidence they need to review to look at, or what they just need to review the record. And if there is not a likelihood of improvement, they should award the PNT. So basically, it's what the examiner says about your hips. And then I would add a statement, to your file that says, and specifically asked to be made permanent and total. Say my hips have not improved. If they haven't, they have actually gotten worse, and it's affected my life and how it's affecting your life. And, that might help sway the person making the decision to make that condition static. I'm assuming that you got a pretty high award for your hips, and that's why they rating for your hips, and that's maybe why they made them set them for future exam. But that's my assumption. It might not be true, but that's sort of what happens sometimes when you get a high rating for one condition. They sometimes just set it for future exam, despite the facts. If it's, in my opinion, if it's that bad of a condition, it's going to really affect you. So There's arguments to be made on both sides, but my thing is just add a statement talking about how it affects you daily. Make sure the examiner knows how it affects you, and how frequently it affects you, and just make the best case for yourself. Matt.
So a lot of the times, the problem with wanting something static or wanting something to be permanent and total is that the problem we have in making an argument is that you're sometimes fighting a negative. So they've determined that it's not permanent and total. They've determined that there is a likelihood of increase of improvement over time, but they haven't pointed out to anything in their decision. They didn't say, for example, this record showed. So a lot of the times, or I shouldn't say a lot of the times, I've only once ever filed, like, for example, an HLR where the sole disagreement I had is this should have been permanent and total, and it wasn't. I wasn't looking for an increased rating or anything like that. I just wanted to turn something static that wasn't. I've only done that once, and it was recent. But I just said to the higher level reviewer, listen, I don't know how to fight a negative. I don't think there's any evidence in the file that could be pointed to show this is going to get better. I don't see any. But I don't know how to say it any more clearly than that. The notice we received as part of the decision didn't point to anything. And so we haven't received notice of how to respond. So on higher level review, I think that you should now change it. And they did. The good thing about that, if that's a type of thing you want to do, higher level review is good for that, because or board direct, because you don't want the ability to add evidence, like an exam or something like that, where they just go ask an examiner what the likelihood of improvement is. They almost never ask that. So why give them an opportunity to add that to the file? So just argue. I mean, we could all be arguing. Every single claimant could be arguing the same thing. No evidence supports your decision. Therefore, reverse yourselves.
Right.
And that's really the best. That's both the best and smartest thing you can do, because they then have to point to something in order to support their decision. Which, if they're able to find something, fine, then you can respond to that. But with them just saying, we think there's a likelihood of improvement in the ether, like, you can just be like, I don't know what you're talking about. You got to be more specific, people.
Right. You haven't properly notified me of your decision. And since he has it sounds like his future exam has come to fruition. You got to argue for yourself now that you're going to be in front of an examiner. Just let them know it's not gotten any better. It's not getting any better. So here we go. More details. I feel like my husband's staggering from the vertigo.
That was from the first one.
Yeah. Just make that clear in your claim. Can chronic fatigue syndrome be claimed as secondary? I hear two sides are fault on.
I would say I would like to jump in real quick and just say I almost never claim chronic fatigue syndrome, and I always advise people to not claim that unless you actually have a diagnosis from a medical professional already existing that is chronic fatigue syndrome. The VA takes that phrase literally. They think that you mean that you've been diagnosed with chronic fatigue syndrome, as opposed to a condition causing chronic fatigue, or undiagnosed chronic fatigue, like could be related to Gulf War syndrome or something like that. So I'm much more successful getting fatigue service connected when I leave the syndrome off of it, because that's a medical term that means something. That's what I was talking about earlier, is without putting yourself in a corner. If you use the phrase chronic fatigue syndrome, CFS, and you don't have that diagnosis, I assure you that the likelihood that VA will pin you into a corner is very high. And even if your records are full of fatigue, I mean, just you could be chock full of fatigue, they'll say, yeah, but they don't have CFS. They don't have chronic fatigue syndrome. So we can't grant this benefit. So I know that's not what their question was, but that's the most important thing about chronic fatigue that I can give.
Matt makes an excellent point and assessment on a number of fronts. Do not box yourself in, number one, on any claim that you make. Try to use, be very strategic about how you word things, and about how you approach a situation. Think about all the possibilities and, the best way to phrase things on a claim form. And I use the same I'm usually use the same method. I don't claim CFS. I claim fatigue. Just like in some situations, not all of them, I claim excessive daytime sleepiness instead of sleep apnea. But that's very fact specific in certain situations.
Now, this person clarified in the comments down that they do have a diagnosis of CFS.
Oh.
So my advice, though, doesn't change, because on your applications, you're not a medical professional. You don't know whether one doctor who would diagnose you with CFS won't later change it to something that's not CFS, and then the VA again could point to that change in diagnosis. So when you put in claims for applications, you want to claim symptoms that are concrete that you experience, and you can identify what you think the source is or what you think the diagnosis is, but you should be very clear to the VA you are not limiting your claim to a single diagnosis or a single theory. You are most likely a layman. Now, the person didn't indicate either here. Unless you're a medical professional, we are all not medically trained, so we shouldn't be using medical terminology with a degree of certainty. Right? You can say, my record contains this diagnosis, therefore that's why I'm claiming it. But again, those diagnoses could change. And then again, the other answer is, could it be claimed as secondary? Just like any other condition. I mean, if it's medically acceptable to be secondary to something, then sure. There's a lot of things that cause fatigue: fibromyalgia, seizures, if they're so strenuous of seizures that they cause. I mean, there really isn't. I wouldn't limit my comment to mean that there's nothing that couldn't cause fatigue. I don't know. I'm not a medical professional again. If the argument is there, make the argument. But sorry, I went long on that one.
No, you're fine. It was a good.
I'm getting more heated as we're going along.
Right.
We're here for like another 7 hours, right?
These are really good questions. Is there a number given to a person's claim? So you have your file number. They do have a claim number, but it's not very useful to know. In the VBMS, there is a specific claim number. Sometimes they give it to you if you request a higher level review, and you get put in the scheduling system. They'll send it in an email or something like that. But unless you're on the docket and at the BVA level and at the court level, it's not very useful, to know the number of your claim. I don't think, Matt.
No, your social is your
sufficient
best number to be referencing whatever claim whatever submission you're making.
Okay, I'm going to take 2 more questions and then we'll be done for tonight. Here we go. Can a person use academic journals to prove their claim for neck pain and DDJ after ACDF is causing, I don't know what ACDF is causing vertigo, dizziness? Basically, the law and the M21 provide that a person can provide medical treatises to support their claim. It can be evidence, but those journals alone don't provide an opinion, a nexus. So while it can be evidence to prove that a certain connection can be made or exist, or something can cause something, causation is possible, it can't give most journals and studies don't give an opinion on your individual claim, and that's what's needed to prove your claim. So that's what I would say about that. And then last question of the night: does my regional office in my state always decide my claims, Matt?
That was the case until maybe 3 or 4 years ago. The AMA may have ramped that up especially, but now what the VA has implemented, which was they've been testing this out for years. I don't think they've ever gotten good feedback on it, but they've stuck with it and they've made it now the default. But it's called the National Work Queue. So if you Googled VA and NWQ, every distinct thing that happens in a claim is now broken down. This is The last question is going to open up a can of worms of my distaste of bureaucracy. This is bureaucracy like at its worst, like with the monster that can be created when you get bureaucratic, right? So the VA works off of manuals. So if there's 50 steps that need to happen in your case could literally go through 50 different hands for each of those stages throughout the country, right? They'll do step one with this person and then they'll pass it on to the next person. I mean, it's like it's like factory line working of claims. I'm sure they thought they had good intentions in doing it. I don't think it helps at all, because the benefit of someone in your state doing it is you could know who to contact, who made the mistake, or who, you knew someone in that building was the person deciding your claim. So if you walked in, they're just, in my mind, there were more benefits to keeping everything local. The good argument that I see why they did that is some states just have heavier demand. Carmella and I are in North Carolina, and North Carolina is an overloaded state as far as work to be done by the North Carolina office. I don't know why that doesn't mean that they didn't just hire a ton of people in North Carolina. I guess I'm saying I can see their argument, but then I can't see why they didn't just hire, like, if there's more people that live in North Carolina and there's more people that live in California and there's few people that live in Delaware, it just makes sense that the North Carolina office should be monstrous and the Delaware office should be small. They didn't do that, though. They decided that everybody should be semi-equal, and the Delaware office can only, handle so little that's all that they're going to be expected to do. I'm simplifying everything, but to answer the question directly, no. And it's more likely that for certain types of claims and things like that it will in fact not be worked by anyone in your state. So
right.
I like the old system.
Right.
I like the old system because I could always have hearings with people that I knew were going to be. There was 1 out of 15 people I knew I was always going to get to meet with. Now it's 1 out of the infinite amount of employees that are in the VA. So.
Right. And the system is called the National Work Queue that they use now. They just move the workload around based on the capacity of each regional office. But you know, things sometimes get decided in your state, but not always. So it's a what I don't like about it, aside from what Matt said, is that things can sit and never land what's called regional office 499 in the system for a long time, and you don't know who has control of it.
That is the worst part of it, is that there's computer limbo, which
Right.
is where the most time that your claim sits. Instead of it being on Bill's desk for a long time and someone saying, Bill, that file's been on your desk for a long time, it can just go to Computer Neverland, and nobody's going to fire Computer Neverland.
Right. Sometimes it gets stuck in Neverland, and the system
Right.
doesn't move it along. And then after months, I have to nudge them, and they say they're going to move it, and they don't. So, I have a number of claims in Neverland right now, and I really don't like it because I need to move them off my plate. But and the veteran deserves a decision. They've been waiting too long. So, it's that's a good question. I'm going to slip this one in because it's just a good question. Can a person who is a provider provide their own nexus? The answer is yes. The law provides for this, case law provides for this, and the M21 provides for this. If you are a medical professional, a nurse practitioner, a physician assistant, or a doctor, a psychologist, a psychiatrist, any other type of doctor, or audiologist, that type of thing, you can provide your own medical opinion for your own case and medical evidence. So I've done it. I've represented a number of medical professionals, doctors, nurse practitioners, physician assistants, and I always have them write their own evidence, and it usually suffices. So if you take advantage of the opportunity and then go back and help other veterans. Thank you guys for joining us. Thank you so much, Matt.
Thank you so much.
You gave so much awesome insight tonight and broke things down in simplistic ways that will help. A lot of veterans will watch this replay, and it will be beneficial for a long, long time because it will live on the internet. So thank you so much for joining us. Thank you for what you do. If you're looking to contact Matt, his law firm is called Matt. You might want to give that
It is
information.
Sutton Snipes, SUTTON SNIPES, SuttonSnipes.com. And it was a pleasure to be here today. I've never been a part of a live Q&A like this, but I had a great time, and I definitely see the value. And for everyone watching and who's been a big fan of Carmella for a long time, Carmella is one of the good ones. And she's an advocate's advocate, and I look forward to seeing how high she rises in this field. I think she's going to be around for a long time, helping a lot of clients.
That's sweet. That's my plan, to do it. Get on as many people nervous to be at that I can. So, and represent the veteran well. So thank you all. Thank you so much, Matt. Thank you again and forever. I'll be grateful. And the veterans are so grateful. And thank you all for joining, watching, tuning in. Tell somebody about the broadcast, and hopefully this helps. Y'all take care. I wish you the best in your claims, and have a good night.
Bye. Good night.